It goes in. All right. Rodney Hill is here. And he's not on the docket. No. Wait, Rodney Hill was yesterday, right? He was yesterday. Yeah, Mr. Grant. Okay. Mr. Hill, if you can start your video first really quick. Good morning, Mr. Hill.
Good morning, ma'am.
You were scheduled yesterday at, was it 1:30? At 3 o'clock yesterday, and your attorney and the prosecutor were here. I don't have your file, so I can't call your case.
I thought it was today.
No, it was yesterday. So go ahead and call Mr. Brandt, and I'm sure you guys can work something out.
I'm sorry,
I didn't issue a bench warrant or anything. Just stand right there by the podium. This is in the matter of the people of the state of Michigan versus Michael Thomas Santamore, file number 24-22074FH. I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Santamore. This is the date and time scheduled for a first pretrial conference in this matter. Mr. Santamore is present in person. Mr. Murphy, how would you like to proceed today?
Your Honor, I was going to submit a request for a competency review and criminal responsibility review in this matter, so I'll just ask for an adjournment. We'll have that submitted to the court today, and whatever the court believes will be appropriate for the time for adjournment is what we're requesting.
Okay, Mr. Sneed, do the people take any position?
I have no objection, Your Honor. Thank you.
All right. So Mr. Santamore, Mr. Murphy's office will prepare that request. It does take several months to go through that process. So I am going to schedule this for April 23rd at 8:30 in the morning. Miss Adams, could I get a notice of hearing for Mr. Santamore? So April 23rd at 8:30 in the morning, we'll give you a notice of hearing. It takes about 90 days or more to go through that process. All right.
Okay, thank you.
Yep. So have a seat right behind you on that bench. No, right behind you.
Okay.
Right there. And then we'll get you that notice of hearing. Okay. Okay. All right. Thank you. And Mr. Murphy, you will not need to do a notice of hearing.
Yes, Your Honor. Thank you. Mr. Santamore, call my office in a week or two, okay? Just to make contact with me, okay?
Okay.
All right, good. Okay, I have Mr. Inclan, you have retained Mr. Sala, correct?
No, ma'am, I'm represented. So.
Okay, for some reason I had Sala down. All right, thank you. All right, Mr. Inclan, why don't you come up to the podium? All right, this is not. This is in the matter of the people of the state of Michigan versus Vincent Matthew Inclan file. This is a district court file, so 24-2619FY. This is a date and time set for a pretrial conference in this matter. I have Isaac Sneed appearing on behalf of the people. There was a probable cause hearing that was scheduled for January 15th. Mr. Inclan didn't appear for that. He did show up the next day, so I advised him about make sure you appear for court on the days you're required to. So at this point, I believe Mr. Sneed's protocol would be he can either set it for a preliminary exam Have the people made any offers of a plea?
Your Honor, just one question is, the defendant in pro per at this time?
Yes.
Okay. The offer was a reduction from the felony to a domestic violence second offense, which is a 1-year misdemeanor.
So, Mr. Inclan, you are charged with a domestic violence third offense, which is a 5-year felony and carries up to a $5,000 fine. Mr. Sneed, does he have any prior felonies?
No, I don't believe so. There would also be a condition of no jail on that offer, Your Honor.
Oh, okay. So, Mr. Inclan, you understand if you were to be found guilty, you could be facing up to 5 years in prison?
Yes, Your Honor.
Okay, and it would be a felony on your record.
Yes,
You
Your Honor.
understand
I
that?
understand.
So what they're offering is to plead it down to a domestic violence second offense, which carries a maximum penalty of up to 1 year in jail with a Killebrew agreement that there would be no upfront jail.
I understand.
And then you would be placed on probation in district court. And as long as you never violated your probation, you would never go to jail.
I understand how that
Do you
works.
understand that plea offer?
Yes.
Okay. Do you wish to avail yourself of that plea offer?
I'm not gonna take the plea offer.
You're not going to take a plea. Are you requesting a preliminary exam?
I am.
Okay, so Mr. Sneed, how long do you'll need for a preliminary exam?
Less than 1 hour, Judge.
All right, Ms. Adams, I'm looking to schedule a preliminary exam date.
Okay.
If I may.
Not yet. You can't talk about the case to me at this point.
I understand.
I mean, there's gonna be a prelim, I'll make a decision whether to bind you over on the felony or not. Understand if you hold the prelim, then the plea offer is withdrawn on cases where there's victims, according to the standard of the prosecutor's office. Do you understand that?
I understand.
Okay.
Judge, we could do Tuesday, February 11th at 9 a.m.
Mr. Sneed, are you available? Is this your case, Mr.? I don't know whose case this is.
Yes, and I am available. Thank you.
All right, Ms. Adams, Mr. Inclan will need a notice of hearing. So, Mr. Inclan, I will set this for a preliminary exam at 9 a.m. Do you understand what a preliminary exam is?
We're gonna go through everything that happened that day.
It's not a trial, it's just a prelim. So at that time, police officer will testify about the events that occurred. The victim may or may not, they don't actually need the victim to testify. And then I'll make a determination whether there's enough evidence to bind you over on a felony. Do you understand? Okay, and February 11th,
Yes.
and February 11 at 9 a.m. means 9 a.m. Got it?
Yes. I believe a motion of dismissal has been signed on behalf of the.
I have not signed a motion of dismissal.
Uh,
You may have filed one, but I don't have it.
AKA the victim.
The victim, okay, you need to understand, even if the victim submitted that, the people don't have to dismiss.
Okay.
Do you understand? Okay,
So will the plea be available still at the preliminary exam, or that's open?
up until the preliminary exam.
Okay.
And once we hold the prelim, usually the prosecutor's office, if there's a victim, I've seen them, they withdraw the plea. Okay, so
They,
I can't advise you of the law. That's what an attorney's for, and you have the right to hire one or get one appointed. So if you want to reach out to the prosecutor, you can do that, but I can't give you advice. All right? Thank you.
thank you.
You too. What day did I say? February 11th at 9.
Yes, February 11th at 9. Yes, Judge.
All right, let's see. I have a waiting room full of people, so I have MDOC, I have jail Zooms everywhere. I have Charles Millie, Brenda Underwood. All right. Who's your attorney?
Underwood.
Glazer. Okay. Hi. Okay, I've got Miss Underwood too. So hold on, let me get your file. You're Mr. Robertson?
Yes, ma'am.
Good morning, Mr. Robertson. So let me grab your file. Miss Underwood, thank you. So this is in the matter of the people of the state of Michigan versus John T. Robertson, file number 25-22106FH. I have Rhonda Underwood appearing on behalf of the Public Defender's Office. I have Isaac Sneed appearing on behalf of the people. And this is the date and time set for arraignment. Mr. Robertson, what facility are you currently at?
Macomb Regional.
Yes, sir. Thank you. So, Ms. Underwood, do you waive the reading of the felony information?
I do, Your Honor.
Thank you. How would you like to proceed today? Have you received?
Well, if I could just have a brief moment with Mr. Robinson, I think we can resolve this.
So, Mr. Robertson, what I'm going to do is open up a breakout room and send you a request to join it. If you're on a Polycom, you'll go automatically. If you're on Zoom, someone will have to do it for you. So let me open that up. And yep, he's on a Polycom. He went automatically. All right. So let me figure out.
Good morning, Judge Inclan.
Good morning. How are you today?
Good, how are you?
I am good. So I am ready for Mr. Wayne Lawfer and Anthony Montoire.
All right, sounds good. I'm gonna have to log in another one for Montemayor just to maybe
right.
forewarn you.
I do have jail 3 and jail 4 open, but
Yeah.
Okay.
As tech, they'll have to be placed in a separate room.
okay, thank you.
You're welcome, man.
Bye-bye.
All right, bye-bye.
See. All right, I have someone named Scott Bugby. Could you start your video, please? Good morning, Mr. Bugby. What case are you here on?
I believe it's domestic violence.
Okay.
That's my matter, Judge.
Oh, yep, there it is. It's one of the, okay, I'm sorry. Miss Underwood, are you done talking to?
Yes, I am, Your Honor. Thank you.
All right, I'll close that. Okay, in the matter of the people of the state of Michigan versus Scott Douglas Bugby. Oh, this is another misdemeanor case on district court. So let me find the little file that they use. Okay. And it's a misdemeanor file number 24-2851 SM. I have Dan Gumtoe appearing on behalf of the people and Charles Noe appearing on behalf of Mr. Bugby. Mr. Noe, is this a pretrial or probable cause? It says pretrial notice.
Pretrial. It's a misdemeanor.
Oh, okay. So it's okay. So Mr. Noe, how do you wish to proceed on behalf of Mr. Bugby?
Judge, I've had some conversations with Mr. Gunpowder regarding where this matter's headed. We agreed to an adjournment on this matter to the pretrial. This is a very new matter. This is the first pretrial. As a matter of fact, this incident allegedly happened 1 month ago to the day. So we are asking for an adjournment to continue those conversations and see where this matter's headed. I guess in terms of time, we probably want at least 30 days, but I leave it at the court's discretion or Mr. Gumtow, because he has to look into some things on his end for timing on his end, so I defer to him.
All right. What about Mr. Gumtow? Go ahead, Gumtow.
No, that's correct, Your Honor. Thank you.
Okay. How about March 5 at 8:30 in the morning?
That's not.
I didn't hear that. Is that okay with you, Mr. Noe?
That is fine.
And Mr. Gumtow?
That works for the people. Thank you.
Okay, so we'll see you back on March 5 at 8:30 in the morning. All right.
On these, Judge, do we have to do it? I don't think because the district court file, is the court going to be issuing a notice? Or you need to step in order?
Oh, no, you can do that step in order to adjourn.
Okay, all right. Mr. Gumtow, may I send that with your permission, please?
Yes, you may. Thank you.
Okay, thank you.
Excellent. Thank you. Have a good day.
Thank you.
Thank you.
Okay, we are back with Mr. Robertson. So Ms. Underwood, how do you wish to proceed on behalf of Mr. Robertson today?
Your Honor, with the court's permission, the offer from the prosecutor in this matter is that Mr. Robertson would plead to the having a weapon provision, Your Honor, and the assault count and the habitual offender notices would be dismissed. If the court would like to take that plea today, I believe Mr. Robertson would enter that plea today.
All right. So Mr. Robertson, want to raise your right hand for me?
Oh, and Your Honor, I'm sorry. We would be asking the court to COBS to the low end of the guidelines.
Mr. Sneed, do people have any position?
I have no position, Your Honor. I defer to the court.
All right, I would do that. Thank you, Ms. Underwood. All right, so Mr. Robertson, good. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Do.
Okay, so Mr. Robertson, you can put your hands down. So, or your hand down. You have heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to count 2, prisoner possessing a weapon, which carries a maximum penalty of up to 5 years in prison and or $1,000 fine? So do you wish to plead guilty to that count?
I do.
All right, and I know that your attorney has discussed this with you, but I want to make sure we put it on the record. Mr. Robertson, do you understand, because this occurred while you were an inmate with MDOC, this sentence will stack to your current sentence. Do you understand that?
Yes, ma'am.
Okay, and so you won't be able to get any credit for time served. Do you understand that?
Yes.
Okay. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
I am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court other than sentencing to the low end of the guidelines. Is that correct, Ms. Underwood?
That's correct, Your Honor.
Is that correct, Mr. Sneed?
Yes, Your Honor.
Is that correct as far as you're aware, Mr. Robertson?
Yes.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, so sir, how do you wish to plead to the charge that on or about May 6th of 2024 in Madison Township in the county of Lenawee, that you did commit the offense listed under count 2, prisoner possessing weapon, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
All right. So, Mr. Robertson, I understand the agreement is that you'd be sentenced to the low end of the guidelines, but has your attorney promised you any particular sentence or estimated what your sentence will be?
No, ma'am.
All right. Is it your own choice to plead guilty?
Yes, ma'am.
Okay. So on May 6th of 2024, were you at the Gus Harrison facility in Lenawee County?
Yes, ma'am.
Would you agree that's located in Madison Township?
Yes, ma'am.
Okay. And at that time, did you have an item that could be used as a weapon?
Yes, ma'am.
Can you tell me what that was?
A shank, a makeshift knife,
Okay. What was it made out of?
steel.
Okay. All right. And you knew that it was a weapon, correct?
Yes, ma'am.
And you knew you weren't allowed to have that.
Yes, ma'am.
And you were serving a sentence, so you were lawfully incarcerated at the Gus Harrison facility?
Yes, ma'am.
All right. Mr. Sneed, are the people satisfied?
Yes, thank you, Your Honor.
Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Mr. Sneed?
Yes, Your Honor.
All right. So, Mr. Robertson, I accept the plea. It has been given understandably, voluntarily, and accurately. You have full knowledge of your rights. You do have competent counsel. Outside of the Cobb's agreement, I've made no other agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, are you available for sentencing on March 7th?
Second, Your Honor.
Seven, lucky seven.
Yes, that's fine, Your Honor.
All right, so Mr. Robertson, I'm going to set this for sentencing on March 7 at 8:15. Someone from our Michigan Department of Corrections, or perhaps from MDOC, I'm not sure how they'll work that out, will talk to you about this offense. Just be truthful with them about your background. The events that occurred, they'll prepare a pre-sentence report. I will provide a copy to Ms. Underwood. She's really good about getting in and meeting with people, but sometimes we do have difficulty getting in and out of MDOC. She usually will talk to you in advance. If she isn't able to, she'll talk to you the morning of and review that with you. And do you want to appear in person or via Zoom, Mr. Robertson?
It don't matter to me.
It's up to you. You know, we have to you have the right to be present in person, but you can appear via Zoom.
I mean, a ride just gets me out of here and gives me something to do. So, I mean, I guess we can go for a ride.
Okay, that makes sense to me. All right, so I will set this for in person, and Mr. Sneed, the prosecutor's office will do the writ, correct?
Yes, Your Honor.
All right, and Ms. Adams, I'll just change that to 8:30 just to give him a little bit more time. All right, so Mr. Robertson, thank you, and we'll see you back on March 7 at 8:30 in the morning.
All right, thank you.
Thank you.
Thank you, Rhonda.
Okay, so. Who do I have from the jail? Mr. Lawford?
Yes, ma'am.
Okay, let me see here, let me find you. Mr. Malaro?
Yes, Judge.
Mr. Lawford? So let me call
Yes,
the
ma'am.
case. This is in the matter of the people of the state of Michigan versus Wayne Leroy Lawford Jr. File number 24-22048FH. I have Salvatore Malaro appearing on behalf of Mr. Lawford, and I have Isaac Sneed, I guess, appearing on behalf of the people. This is the date and time set for a pretrial conference. Or is it Mr. Gumto? Who's my prosecutor on Mr. Lawford?
Your Honor.
Mr. Gumto appearing on behalf of the people. So, Mr. Malaro, how do you want to proceed with Mr. Lawfer?
Your Honor, there may be a plea in this matter. If I could have a quick breakout with Mr. Lawfer to make
All right.
details of what we're gonna do.
So, Mr. Lawfer, I'm going to open up a breakout room.
Thank you.
Yep, jail room 4, and put you in a breakout room. Mr. Malaro, there he is. Go ahead and join that breakout room. All right, let's see who I got. Mr. Montoire will be with you in just a moment. I have somebody I just admitted on an iPhone device. I'm going to send you, where'd you go? Could you, I unmuted you at the same time you muted, so could you unmute your device? What is your name, please?
Amir Norman.
Say it again.
Amir Norman.
Your Honor, that's Amir Norman. He's my client.
Norman.
Norman, okay. All right, there we go. Let me change your screen name, sir, so I do not lose you in the mix. Okay, so this is in the matter of the people of the state of Michigan versus Amir Norman, file number 24-21913FH. Ms. Underwood represents Mr. Norman, and I need a prosecutor. So Mr. Gumtoe, Mr. Sneed, Mr. McCready. Mr. Gumtoe again. So Ms. Underwood, how do you wish to proceed with Mr. Norman today?
Can I have a breakout with Mr. Norman, Your Honor? Thank you.
All right. So Mr. Norman, I am going to send your request to join a breakout room to go talk to your attorney. So just go ahead and join that. If you can't figure out how to leave it, you probably start your video too. I'll bring it back myself, okay?
Thank you.
Same song is. Right, I just admitted somebody on a Samsung device and it sent you a request to unmute.
Unmute. Okay, sorry about that.
Okay, what is your name, please?
Lindsay Blumhart.
All right, let me get you here. There you are. Mr. Murphy, that's your client. So let me change her screen name. All right, so in the matter of people of the state of Michigan versus Lindsay Blumhart, file number 24-21978FH, I have Matthew Murphy appearing on behalf of Ms. Blumhart, and I need a prosecutor, Mr. Gumtoe, Mr. McCready, or Mr. Sneed, somebody. Mr. Gumtoe appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Murphy, how would you like to proceed?
Your Honor, could I have a brief breakout with Ms. Blumhart? I just talked to her on the phone, but I just needed to clarify something with her.
All right, Ms. Blumhart, I'm going to send you a request to join a breakout room. Go ahead and join that breakout room. All right. Let me see here. All right, Mr. Ryan, your attorney is Mr. Malaro, correct? Yep. So I am going to add his initials after your name. He is with another client right now, and as soon as he is done, I will bring you back in, okay?
All right, thank you.
You're welcome. I'm gonna pop you in the waiting room. Okay. right, Mr. Murphy. Let me bring Ms. Blumhart back. All right, so Mr. Murphy, we are back on the record with Ms. Blumhart. How would you like to proceed today?
Your Honor, I was communicating with Ms. McClure in regards to this matter. There is an offer for a misdemeanor that would involve, by the prosecutor, they're requesting entrance into mental health court. I'm asking for an adjournment just briefly, a couple of weeks is all that's necessary, to look into the matter to see if that's available or not. And then we'll move forward with the case. If not, we'll probably set a trial at that point. But again, I'm just asking for a couple of weeks if the court can find a schedule to do that.
My next available is March 5 at 8:30 in the morning. So I will set a pretrial for March 5 at 8:30 in the morning. Obviously, if there's a resolution, Mr. Murphy, you can call my office and we will schedule you in for a plea. All right?
Yes, Your Honor. Thank you.
Can you do the stip in order to adjourn?
Yes, Your Honor. My office will do that stipulation in order for March 5th at 8:30.
All right, Mr. Gumtow, he can sign your name with permission.
Yes, Your Honor. Thank you.
All right, so Ms. Blumhart, we'll see you back on March 5 at 8:30 in the morning, if not sooner, all right?
Okay, and will that be another Zoom or will I go to court that day?
Yep, same Zoom number.
Okay, thank you.
Thank you.
Mhm.
All right, so Ms. Underwood.
Here.
Organize this. Who are you in with, Mr. Norman? Still in a breakout room, Mr. Montoire, just in that. All right, Mr. Norman, we are back. So, Ms. Underwood, have you had a chance to speak with Mr. Norman?
Your Honor, the plea offer in this case, as I've explained to Mr. Norman, is minimal. Mr. Norman can plead guilty to the 5-year felony, and there will be a no upfront jail provision. I've explained that to him, and Mr. Norman wishes to accept that deal.
Okay, and as part of that, well, it says no subs. Does he have any supplements?
He does not.
Okay. All right, so the plea offer is to plead to count 1 retail fraud first degree, which carries a maximum penalty of up to 5 years in prison, restitution, and the plea agreement is to no upfront jail. Is that correct?
That's correct.
All right. So, Mr. Norman, where'd you go? Mr. Norman, I'm going to need you to start your video for this. Is that all right?
Yes.
Oh, there. Okay. All right. So, Mr. Norman, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? He's freezing. So, Mr. Montoire, Mr. Loffer, I am going to put you in a breakout room or into the waiting room because I think our bandwidth is a little overwhelmed. So I'm going to put you in a waiting room and bring you back in just a minute. Ms. Teskey, I'm going to stop your, can you stop your video? Okay, so hopefully that'll help, Mr. Norman. All right, so Mr. Norman, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to count 1 retail fraud, which carries some?
We didn't get his response.
Oh, I heard it. I'm sorry.
Okay.
Mr. Norman, do you swear to tell the truth then? Could you repeat your response?
Yes. Yes.
Okay, thank you. So Mr. Norman, the plea offer is to plead guilty to count 1 retail fraud first degree. As I said, it carries a maximum penalty of up to 5 years in prison, but there is an agreement that there would be no upfront jail. Is it your intention to plead guilty to that count, sir?
Yes.
Missed your response. I'm sorry. I'm so sorry.
Yes.
It is. Okay. Miss Adams, I also don't have a copy of the felony information for this file. In the file. You can print that off for me.
Okay.
Thank you. All right. So, sir, are you satisfied with your attorney and the advice that she has given you?
Yes.
Right. And neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
That's correct, Your Honor.
And Mr. Gumtoe?
That's correct, Your Honor.
All right. Mr. Gumtoe, does he have any prior retail frauds?
If you can give me one
I'm assuming
second.
it does. Yeah.
Yeah. No, it doesn't look like he does, Your Honor.
Okay.
Your Honor.
All right. Yes.
Can I have another minute with my client?
Yes. Okay. Hold on a second. All right, I'm gonna open that breakout room. I'll go on to another case. Go ahead and join it again. All right. So, Mr. Norman, go back and join that breakout room. All right, Mr. Malaro, let me bring in Mr. Lawfer. Oh gosh, what was he? Shall Zoom 3?
Yes.
I'm like 3, 4, 1.
Lawfer was 4, Judge.
All right, we were both wrong then. Let me bring him back in. All right, sorry. Thank you, Mr. Lawfer. All right, so we are back on the record in the matter of the people of the state of Michigan versus Wayne Leroy Lawfer Jr. So, Mr. Malaro, how do you wish to proceed on behalf of Mr. Lawfer?
I think we have a plea.
Mr. Malaro, I am so sorry, but could you try that again?
Yeah. Can you hear me now?
I can hear you now. Yes.
All right. I think, Judge, we have a plea agreement. So I'm gonna read into the record, and if Mr. Gumtow is in agreement, then I think it's Mr. Gumtow. We can get this worked out. So my notes say that Mr. Lawfer is going to plead to an attempted resisting and obstructing a 1-year offense and OWI, and then there is a district court case 24-2092 SD. Counts 1 and 2 are going to be dismissed. I'm pretty sure that is the plea agreement. Mr. Lawfer is
I
willing
don't
to.
have an OWI in my file.
Oh, I thought you did.
No, I don't have an OWI. All right, I'm gonna skip this while you guys figure that out and go back to Mr. Norman. So, Mr. Norman and Miss Underwood. Miss Underwood, how do you want to proceed on Mr. Norman's behalf?
Your Honor, I think I want to set the, with apologies to the court, I want to set this for another pretrial, and perhaps Ms. McClure and I can have a conference with the court.
Okay. So I'm going to set this over to March 5 at 8:30 in the morning. Mr. Norman, March 5 at 8:30 in the morning. Write that down. We'll mail you a notice, but just in case. And it's the same Zoom number, all right, Mr. Norman?
Okay, thank you.
Thank you. And Ms. Underwood, you'll do the stip in order to adjourn.
I will happily do that with Mr. Gumtow's permission.
All right, thank you.
Thank you.
Okay. All right, so Mr. Malaro is talking to whoever. Okay. I got Mr. Dagger Margosian.
Judge Angelone.
Good morning. So now I have Mr. Daggermark goes in. So if you can, I know I'm hogging all your Zoom rooms. I am ready whenever you are on Kayla Walden.
Okay, we'll have to wait till Montemayor's out.
That's fine. That's fine.
He's taking our female room, so.
Okay, thank you.
As soon as he gets out, I'll put her in, okay?
All right, thank you. Bye-bye.
Bye-bye.
All right, Judge, we cleared up Mr. Lawfer's issue.
All right, so we are back on the record with Mr. Lawfer. So again, Mr. Malaro.
So, Judge, it is plea agreement to the attempted resisting and obstructing a 1 year. And on the district court case, which this court does not have jurisdiction, Mr. Lawfer will plead to a regular OWI, which will be an amended and counts 1 and 2, the high BAC and the license plate charge will be dismissed. That's scheduled for hearing on February 6th. So that is the plea agreement.
That's correct, Your Honor.
All right, thank you, Mr. Gumtove. All right, Mr. Lawfer, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record, please?
Wayne Leroy Lawfer Jr.
All right, thank you, Mr. Lawfer. So, Mr. Lawfer, you've heard the statement of your attorney and the prosecuting attorney. My file is it your intention to plead guilty to an added count 2 attempted resisting and obstructing, which carries a maximum penalty of up to 1 year in jail, but is a misdemeanor. And then you will be pleading to an OWI in district court and some other matters will be dismissed. Is that your intention?
Yes, ma'am.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That's correct, Judge.
Mr. Gumto?
That's correct, Your Honor.
And Mr. Lawfer, is that correct as far as you're aware?
Yes, ma'am.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, sir?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so sir, how do you wish to plead to the charge that on or about October 26th of 2024 in the city of Hudson in the county of Lenawee that you did commit the offense of attempted police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Judge.
Mr. Gumto?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Mr. Lawfer?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
so Mr. Lawfer, on October 26th of 2024, were you in the city of Adrian in the county of Lenawee?
Judge, it was City of Hudson.
I'm sorry, city of Hudson in the county of Lenawee?
Yes, ma'am.
All right, and at that time, did you come in contact with a Hudson police officer named David McKeon?
Yes, Your Honor.
All right, and when you saw him, did you know he was a police officer? Could you see a uniform?
Yes, ma'am.
Okay, and was he working at that time?
Yes, Your Honor.
Okay, and did he try to take you into custody or something or stop you?
Yes, Your Honor.
He tried to arrest you?
Yes, ma'am.
All right, and so tell me what you did. Did you push his hand away? Did you run? Did you kick him? Did you punch him? Like, tell me what you did to resist arrest.
I was kind of alarmed and I pulled my hand back away from him and stumbled back. We were on an incline.
Okay, so he was trying to handcuff you and you pulled away from him?
Yes, ma'am.
Mr. Malaro, you had something to add?
Mr. Lawfer, did Officer McKean identify himself as an officer at that point in time?
Yes, he did.
And he had informed you were under arrest?
Yes.
And when you pulled away further, you resisted in some form his attempt to handcuff you, is that correct?
Yes.
And ultimately you ended up on the ground and then were handcuffed?
Yes.
Is the state and court satisfied, Your Honor?
Yes, Your Honor.
I am. Mr. Gumtow, are you satisfied?
Yes, thank you.
And Mr. Gumtow, you'll get me an amended information by the end of the day, please.
Yes, Judge.
Thank you. Thank you.
Your Honor.
All right.
Your Honor, could the court advise me as to what his bond is on this case?
Let me finish my spiel because if I lose my place.
Sorry, Judge.
So has the court complied with MCR 6.302 B, C, and D? Mr. Malaro?
I believe the court has.
Mr. Gumtow?
Yes, Your Honor, I believe so.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement with the prosecutor or regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, are you available on March 7 at 8:15 in the morning for sentencing?
Yes, I am.
All right, so now I'll address bond before I go on further, and I don't know what his bond is, so I'm looking right now. And well, it looks like he was out of jail. And then he was in jail. Let's see, original charge, authorization, filing date, $5,000 bond set back in October. He was given a $5,000 PR bond in, I don't know, November 12. So he got out of jail. And you got out of jail about then, didn't you, Mr. Lawfer?
When was that, ma'am?
Back in November?
I've been here since November 16th, ma'am.
Okay. And hereby ordered, I show we got a $5,000 PR. Miss Spade, we're gonna pause for a minute because I can't read these district court ROAs. So Miss Spade, tell me what's going on.
The magistrate changed it to 5,000 PR bond. It was originally cash bond, but it was changed on arraignment date on October 29th. So, it was changed by Judge Morgan. The magistrate would have set the 5,000 cash or surety, and then the judge changed it to 5,000 PR. He was here for the next date. He's been here ever since.
Okay, so you got out of jail for a hot minute and then you went back to jail, Mr. Lawfer?
Yes, ma'am.
Okay, why'd you go back to jail? The new charge?
Judge, he went back because Can you hear me? Yeah, there we go.
Yeah,
Judge, he was remanded back to jail because he tested positive. I wasn't sure if it was on this file or the other file.
what did he test positive for?
Alcohol. Yeah.
No alcohol bond condition.
But is he remanded on mine or the OWI?
That's.
I don't know if it's my file or the misdemeanor file, so let me.
Judge,
Yes.
Judge, our ROA says he's still under PR bond.
Yeah, he's got a PR bond on my file.
Okay, that's fine, Judge. Thank you. I'll see if I can't get him into district court sooner and address it there. Thank you,
So
Judge.
Mr. Loffer, if you get out, they're gonna make you alcohol test or wear one or whatever, so don't be drinking, all right?
Yes, Your Honor.
Okay, so I am going to schedule this matter for sentencing on March 7 at 8:15 in the morning. So a couple things. So Mr. Loffer, if you remain in custody, Mr. McCarron will come speak to you at the jail and do a PSI for me and one for the misdemeanor case. If you get out of jail, you need to go report to Mike McCarron in district court probation as soon as you get out of jail, so he knows where you are. And you're gonna have to meet with them and he'll do a pre-sentence report. We'll give a copy to Mr. Malaro. Mr. Malaro will meet with you about that. And then we will see you back on March 7 at 8:15 in the morning. So you may be in jail, you may not be in jail. Do you want to appear in person for sentencing or via Zoom?
In person, please.
Okay, so I will put down that you're going to be in person. So remember, if you get out of jail, go see Mr. McCarron right away and let Mr. Malaro's office know your address, okay?
Yes, ma'am.
I'm on the 3rd floor of the courthouse for my sentencing, but district court probation is the one you'll report to, okay?
Yes, Your Honor.
All right, very good. You're all set,
Thank you,
Mr.
Judge.
Loffer.
Thank you.
Thank
Thank you,
you.
Your Honor.
Mr. Glazier, you want to come on up? I have Mr. Glazier. Come on up to the podium. Are you gonna need to see Mr. Montoire, Mr. Malaro, because he's holding up my window?
No, I don't.
You don't need to talk to Mr. Montoire? Okay. All right, so Mr. Glazier,
Yes.
I have Mr. Davis, right?
Yep.
I have Mr. Davis. Okay, this is in the matter of the people of the state of Michigan versus Zachary Davis, file number 24-22014FH. I have John Glazier appearing on behalf of Mr. Davis and Dave McCready appearing on behalf of the people. I have a letter dated January 16th of 2025 from Darren Coast, our pretrial services coordinator. Mr. Davis continues to do well with his Scram device. We have not had any positives since November 21 of 24. He is also still participating with domestic violence counseling with Sally at Recovery Roads. Her reports on Mr. Davis are always positive. So she's wonderful, isn't she?
Yeah, I like her.
So, Mr. Glazier, your client appears to be doing excellent on bond. So, Mr. Glazier, how would you like to proceed today?
I think I need to speak with Mr. McCready.
Okay, well, you can do that via text, okay, or call him. So I'll give you a breakout room, but I don't usually give breakout rooms for prosecutors in case I need them. So let me.
Dave, you got my number, or I don't seem to have you.
I'm gonna put you in the breakout room right now, but typically, Mr. Glazier, it's easier just to call them. Okay, so why don't you have a seat at that council table, please? Yep. Okay, so let's see who I have. It's Mr. Malaro. Okay, so let's go to him. This is in the matter of the people of the state of Michigan versus Anthony Michael Montoire, file numbers 23-21632FC, 24-21744FH. I have Salvatore Malaro appearing on behalf of Mr. Montoire, and I have Isaac Sneed appearing on behalf of the people. I have in my hand a copy of a plea agreement that has been signed by Mr. Montoire, Mr. Malaro, and Mr. McCready, who I just put in a breakout room. So I'm gonna close that breakout room because I need Mr. McCready. Okay, I'm sorry, I needed Mr. McCready. So Mr. McCready, I have a plea agreement form on Anthony Montoire.
Correct.
Okay, so the plea agreement, as I have, is that the defendant will plead guilty in file number 23-21632 FC to count 1, child sexually abusive activities. Let me get the file. Which carries a maximum penalty of up to 20 years in prison and or $100,000 fine. And then he will plead guilty. Oh, wait, and count 5. Wait, and count 32 FC, count 1, child sexually abusive activity, and count 5, which is criminal sexual conduct first degree, which carries a maximum penalty of up to life in prison. But I'll get to that part next, which could carry a maximum penalty of up to life in prison. And then on file number 24-1744 FH, he will plead guilty to count 1, aggravated child sexually abusive activity, which carries a maximum penalty of up to 25 years in prison and or $125,000 fine. All other counts and his supplements would be dismissed. There is a Killebrew agreement between the prosecutor's office and the defendant that his sentence would be a concurrent sentence of 140 months to 300 months, which is 12 years to 25 years with the Michigan Department of Corrections. All remaining counts and subs would be dismissed. Conviction of this crime will result in defendant being required to register under the Michigan Sex Offenders Registration Act for life, and also will require him to be sentenced to lifetime electronic monitoring. And is that a correct recitation of the plea, Mr. McCready?
The plea form that we signed did indicate that it expired on January 15th, because that was supposed to be our final pretrial. That was adjourned until today, and so I have left the offer open just for clarification. And yes, otherwise that is a accurate recitation of the plea agreement.
Okay, so hold on. So, Mr. Malaro, is that a correct recitation of the plea?
It is, Your Honor.
Okay, so let me get this. All right, so Mr. Montoire, you want to raise your right hand for me? Thank you. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? I'm sorry, the room you're in kind of has wonky sound, so can you repeat that again?
Yes.
Okay, thank you. Have you have heard the statement of your, well, I've read through the plea agreement and both the prosecutor's office and your attorney have agreed that was a correct recitation of the plea. So do you intend to plead guilty on file number 23-21632 FC to count 1, child sexually abusive activity, which carries a maximum penalty of up to 20 years in prison, and count 5, criminal sexual conduct first degree, which can carry up to life in prison or any term of years. So on that file, is it your intention to plead guilty to those 2 counts? I'm sorry. Can you scoot up a little bit?
Yes.
I'm sorry, it's the room. It's not you, it is the room. Okay, and then on file number 24-21744FH, is it your intention to plead guilty to count 1, child sexually abusive activity aggravated, which carries a maximum penalty of up to 25 years in prison? So is it your intention to plead guilty to that count?
Yes.
All right. Okay, thank you. So, and you understand the sentencing agreement is that you will serve a concurrent sentence on these files of 140 months to 300 months. And you understand that?
Yes.
Okay, are you on parole or probation or anything right now? Okay,
Nope.
good. All right, are you satisfied with Mr. Milaro as your attorney and the advice that he has given you?
Yes.
All right, so other than the agreement placed on the record, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Mr. Milaro, is that correct?
That is correct, Your Honor.
And Mr. McCready, is that correct?
Yes, it is.
And Mr. Montemire, is that correct as far as you're aware?
The only thing I was confused about was Milaro said that I might not have to do lamb. So,
You might not have to do what?
lifetime monitoring. We talked about that yesterday, but he, I don't know, I guess that changed.
Yeah, Mr. Montemayor, I explained to you I wasn't certain, but when I went back and looked, because the jail doesn't allow me to do it on my computer's blocked in the jail, it is subject to lifetime electronic monitoring. So it is.
Okay.
So you understand that? Do you still wish to enter the plea?
Yeah.
Okay. All right, so if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have a right to a speedy public trial by jury. I think we're actually set for trial maybe. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand? Do you understand that, Mr. Montemire?
Yeah.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
If you're not a citizen of,
Didn't pick up that one.
okay, I hear it. That's okay. I'm sorry, Mr. Montemire. So our recording systems, can you scoot up a little bit? It's not your fault, and I apologize. I really do. Can you repeat your response to that?
Yes.
Okay. Do you have any question? And you understand fully the requirements for registration and lifetime monitoring under the Michigan Sex Offender Registration Act, right? You understand all of that?
Yeah, it's a little vague on the other part right now.
Well, you know, you have to register for life under the Michigan Sex Offender Registry, right?
Yeah.
And you understand that there'll be a tether. You'll be required to wear that for the rest of your life as well.
Okay.
So you understand that?
Yes.
Okay, and again, you're willing to enter this plea, correct?
Yes.
Okay. Do you have any questions about the rights that I've given to you?
No.
Okay. So on file number 23-21632FC, Mr. Montemire, how do you wish to plead to the charge that on or about January 5 of 2022 in the city of Adrian in the county of Lenawee, that you did commit the offense under count 1 child sexually abusive activity, guilty or not guilty?
Guilty.
And under count 5, criminal sexual conduct, first degree, guilty or not guilty?
Guilty.
And then on file number 24-21744FH, how do you plead to the charge that on or about October 15 of 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of child sexually abusive activity aggravated under count 1, guilty or not guilty?
Guilty.
All right. Mr. Montoire, has anyone made any threats or promises to you to plead guilty to these charges, other than what was placed on the record? I'm sorry, can you repeat that again?
No.
Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Judge.
Mr. McCready?
No, Your Honor.
Mr. Malaro, can you repeat that again?
No, Your Honor. No,
So
Your
sorry.
Honor.
So sorry. So sorry. All right. So Mr. Montoire, there is a total plea in this case that includes a Killebrew agreement with the prosecutor and the defense for a sentence, but has your attorney promised you any other particular sentence or estimated what any other part of your sentence would be?
Just that I would probably get the minimum.
Well, there is no minimum in your case because there's a sentencing agreement. Your sentence is going to be 140 months to 300 months with the Michigan Department of Corrections. That's going to be your sentence. Whether you get out at 140 months or later is really up to how your behavior is in MDOC and MDOC. I have no control over that.
Okay.
Do you understand that?
Yes.
Okay. All right. Let's start with file number 23-21632FC. Mr. Montoire, on January 5 of 2022, we in the city of Adrian in the county of Lenawee.
Your Honor, if I may interject here, this is actually a continuing offense, so it's between the 5th of January and the 2020 to October 16th to 2023.
And that's file number 23-21632FC.
We did file an amended information on January 9th.
Well, I don't have that. So what are the dates again?
January 5, 2020 to October 16, 2023.
Okay, so during that time period, Mr. Montoire, were you in the city of Adrian in the county of Lenawee? I'm sorry, Mr. Montoire, if you can sit up, please. Okay, so Mr. Malaro or Mr. McCready, you may need to help me out on that or on the factual basis for this. So Mr. Malaro, do you wish to inquire of your client?
Yes. Can the court hear me?
I can now, yes.
All right. So Mr. Montoire, on those dates in Adrian, city of Adrian, county of Lenawee, state of Michigan, is it true that you did prepare or attempted to prepare, produce, or make child sexually abusive material contrary to Michigan Compiled Law 750.145 C2A?
Yes.
And you understand what child sexually abusive material is, yes? Is that a yes?
Yes. Yeah.
And you understand that that's contrary to the laws of Michigan and an offense under those laws?
Yes.
Is the state and court satisfied?
Mr. McCready, are you satisfied?
On that count, yes.
Okay, so we're going to move on to count 5. Mr. Malaro, do you wish to inquire of your client for the factual basis? Well, I can actually on this one. So Mr. Montemire, during that time period in the city of Adrian in the county of Lenawee, were you engaged in sexual penetration, to wit, penis to vagina, with an individual with the initials of AS?
Yes.
Okay, and Mr. McCready, this involves a delivery of a marijuana to a minor. Is that correct, Mr. McCready?
That's correct.
And Mr. Montemire, had you provided marijuana to that individual?
Yeah.
Okay, and was that individual under the age of 16?
Yeah.
So you would agree she was a minor?
Yes.
Okay, Mr. McCready?
Satisfied.
All right. All right, so on this file, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro
I believe the court has.
and Mr. McCready?
Yes.
All right, so let's move on to file number 24-21744FH. So Mr. Montemayor, on, is it amended? Is this, let me see here. All right, so on October 15 of 2023, were you in the city of Adrian in the county of Lenawee?
Yes.
All right, and at that time, Mr. Malaro, I don't really have the factual basis behind this. Do you want to voir dire your client?
Sure, certainly, Your Honor. Mr. Montemayor, I know date and time and the place the court just described. Did you also attempt to or arrange for, produce, make, copy child sexually abusive material involving a prepubescent child?
Yes.
And you knew this, you know what prepubescent is, right?
Yes.
Okay. And that you did that so in contrary to Michigan compiled laws 750.145
Yes.
And you knew what you were doing was contrary to the laws of the state of Michigan.
Yes.
And it constituted a crime.
Yes.
Is the court and state satisfied?
Mr. McCready, are you satisfied?
Your Honor, if I may. Mr. Montemayor, you had child porn on your phone, is that correct?
Yes.
And the child in question was an infant, is that correct?
Yes.
All right, people are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro
I believe the court has.
and Mr. McCready?
Yes.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Obviously, there is a Killebrew agreement that was made between the prosecutor's office and the defendant for sentencing. I'm going to refer this matter to the probation department for a pre-sentence investigation. I will set sentencing for March 7 at 8:15 in the morning. Mr. Montemayor, you have the right to be present in person, or you can appear via Zoom. So how would you like to appear for sentencing?
Zoom's fine.
Okay, we'll do Zoom. Mr. Montemayor, as I said, someone will come over and meet with you, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report, and I will provide a copy of that to your attorney. Your attorney will meet with you in advance of sentencing and review that with you, and we will see you back on that day. Thank you, Mr. Montemayor.
Yeah.
Hey, girl.
Yeah.
Mr. Stimson, I do not have a jury room available today, or at all this week, so you can use Judge Olson's if you'd like. Okay.
You know, Ms. Francis is in person.
It's scheduled in person, so, but it's 10:30. So, all right. So we are back with Mr. Davis, Mr. Glazier. Are you ready to proceed on Mr. Davis?
Yes, Your Honor.
All right, so, Mr. Davis, go back and stand at the podium. All right, so, how would you like to proceed today on behalf of Mr. Davis?
Your Honor, I think Mr. McCready had a request to make before we to adjourn it, but he wanted to have an evaluation done. And was going to ask Your Honor who some questions about who that should be, I believe.
What kind of evaluation?
Yeah, in order for us to make an offer that we're comfortable with, I'd like to get a psychological evaluation of the defendant and the complainant in this matter. And I haven't been able to find a suitable candidate, and I was hoping Your Honor could.
We don't ever order those or have anybody to do those that I'm aware of.
I guess informally, does the court
I mean,
know
he's
someone
going,
that?
we have no one that we use. He can, you and Mr. Glazier, perhaps if he has insurance, he is in counseling with Sally Welch. She may be able to do that. We don't have anybody we use, nor do I order that.
I did the Adrian.
Psychiatric?
Yeah.
So he has one he's already done. Would you release that to your attorney?
I already, they should have.
He said he already signed releases to his attorney.
The foster care lady has all that stuff.
The foster care lady has all that stuff?
For the
abuse neglect case?
For what?
Do you have a abuse neglect case for a child? So
kinda.
You might have different courts going on, but we don't have access to each other's records. So if you had one done, you can sign a release to allow that to be released to your attorney.
Okay.
But Mr. McCready, I don't order those, nor do we have anybody we order those with.
Yes.
That's something we order as a term of probation through MDOC, but I don't do that preemptively. So he may have already had one done and he can release that to his attorney to give to you.
That's a good start.
Okay, all right. So how far out do we need this adjourned?
I don't know. I guess Mr.
March 5 is my next available day. Is that too soon or too far? I mean, it's as soon as I have.
That should work.
I think so.
All right. Ms. Adams, I will need a notice of hearing from Mr. Davis. So March 5 at 8:30 in the morning, and you won't have to do the notice of hearing, Mr. Glazier, because I will serve Mr. Davis in the courtroom. All right, very good. Thank you.
Mr. Davis, set up an appointment to come into my office as soon as you can, okay?
Okay.
All right. So, Miss Underwood, I do have a extradition, so just have a seat right there and we'll get you that notice. So let me call for that. And
Hello, Judge Inglow.
hello, so I'm ready for Jonathan Paul.
Okay, I'll let him know.
Hi, thank you.
You're welcome.
Bye. And that should take care of. Who's Jonathan Paul? What do I have here? Oh, Becky, can you call him again and tell him I'm ready on Mr. Cooper too?
Oh.
Right, that's the extradition. I think I'd rather have that one first too. All right, so we have her, let me see, Ms. Walden. This is in the matter of the people of the state of Michigan versus Kayla Ray Walden, file number 25-22101FH. I have Michael Dagger Margosian appearing on behalf of Ms. Walden. What's this look like? Hold on. Is the date and time set for a pretrial in this matter. So I have Michael Dagger Margosian appearing on behalf of Ms. Walden, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for pretrial. Mr. Dagger Margosian, how do you wish to proceed with Ms. Walden?
Your Honor, could I have a breakout room with her, please?
So let me open a breakout room. And Ms. Walden, give me just a second. And there you go. Okay, so I have Brenda Underwood, I have Salvatore Malaro. Let's see what we got. Okay, in the matter, oh, he's in jail. So I won't issue a bench warrant for him. Mr. Malaro. I have Raymond Ryan. Do you have Raymond Ryan with you, Mr. Malaro?
You should be in your Zoom, Your Honor,
Oh,
somewhere.
there he is. Oh, I got Mr. Murphy too. So hold on. Mr. Murphy, did you have Mr. McLean with you?
Yes, Your Honor.
All right. So Raymond Ryan, can you start your video, please, and unmute your device? All right, this is in the matter of the people of the state of Michigan versus Raymond Gilbert Ryan, file number 24-21907FH. I have Salvatore Malaro appearing on behalf of Mr. Ryan, and I have Mr. Gumtow or Mr. Sneed? Mr. Gumtow appearing on behalf of the people. This is the date and time set for a pretrial conference in the matter. Mr. Malaro, do you anticipate a plea today? Because I'm on a roll. Everybody's pleading today. So
I anticipate a plea, but not today. The plea agreement that Mr. Gumtow and I have reached involves these cases being nollied. So I'd ask to adjourn this out past, I think it's February 13th.
my next available date is March 5 at 8:30 in the morning. So
we would
Mr. Malaro.
I would expect these to be nollied by then, Judge.
Okay. All right. So I'm going to set this for another pretrial, Mr. Ryan, but obviously if this file gets nully pressed, you will not need to appear on that day, okay?
Okay.
All right. So I'll see you back maybe. All right. Thank you, Mr. Ryan.
Thank you, Judge.
Malaro doing the stipend.
Mr. Malaro, you do the stipend order?
I will gladly do the stipend order for you, Your Honor.
Okay. All right. So now I have Mr. Murphy. You have your client with you?
Yes, Your Honor.
All right. Hold on. I'm putting a weird note in the file. Okay. So, all right, in the matter of the people of the state of Michigan versus Ricky Jean McLean, file number 24-21850FH. I have Mr. McCready. Are you on the spot?
I am, Your Honor.
I have
Yes.
Mr. McCready appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. McLean. So, Mr. Malaro, how do you wish to proceed? Or Mr. Murphy, how do you wish to proceed today?
Your Honor, we're going to ask to set a one-day jury trial on this matter.
We are set for trial on February 4 at 9 a.m.
Then we're just asking for it to continue to trial, Your Honor. At this point, I think there may be a
Have the prosecutor provided their jury instructions of voir dire questions?
We have not submitted anything, Your Honor. We've offered disturbing the peace on this. I was hoping just to resolve it short of trial. I think he's maybe considering the offer still.
All right,
Yes.
jury questions and voir dire questions were due on January 15 of 25. He's charged with 1, 2, 3 4-year felonies, which could result in up to 4 years in prison. And the plea offer is to plead to the count 4 disorderly, which is a 90-day misdemeanor, which was a 90-day misdemeanor. And then count 1, 2, and 3 would be dismissed. So Mr. Murphy, at this point, how do you want to proceed?
Again, Your Honor, I talked to my client. At this time, he does not wish to accept that offer. We're asking for it to continue to the jury trial, unless, again, that's my anticipation. I am going to speak with my client further and notify the court if there's a change in his decision.
Okay, that's fine, but jury instructions and voir dire questions are due this Friday by 12 noon. They were due
Yes,
the
Your Honor.
15th, and I have not received them from anybody, so I expect them by Friday at 12 noon, or he pleads by that time. All right?
Yes, Your Honor.
Excellent. Thank you both, and we'll see you at trial.
Thank you.
All right, so let's go back to, I have nobody at the jail. Nobody. All right, I'm gonna step off the bench, take these files to Ms. Adams.
I'm sorry?
So good
Oh, good morning. How are you, David?
Cold, otherwise
Yes, I agree.
it's quite chilly outside.
Oh, my goodness. Is it still breezy?
Yeah.
Oh.
Can you hear me, Mike? How are you doing?
Hey, Dave, how's it going?
Living a dream. What's this business here? It's a little salt and peppery there, bud.
Yeah, man. Well, I got, you see it through screen? Yeah, I got some white in there.
Yeah. Go for that business, man.
I got to go the Ryan Day route.
What'd you do, Dave?
No. Don't even mention that, man. That's a horrible.
I know. No, I hate that, man. I would never.
His goes in all white trashy, so don't do that either.
You're telling me to not Sharpie my beard black like
Right,
Ryan? Is that what you're saying? All right.
Exactly. I mean, if
What's
you've ever seen
going
the
on?
movie, if you've ever seen the movie Joe Dirt, you know that I don't grow in a beard for a reason.
Yeah.
We're live on YouTube, so there are no talking.
Sorry, Your Honor.
Thank you. All right, waiting for the speed.
Yeah, well.
Yeah.
Please rise for court zone session. You see.
Sorry, Mr. Simpson. Attorneys misbehave at the best of times. I just don't want it on YouTube.
I'm always
So-
on my best.
All right, then I spilled some tea and not in a good way. Mr. Dagermer goes in, so let me wipe up my mess. All right, go. Okay, so we are back on the record in the matter of the people of the state of Michigan versus Kayla Walden. So Mr. Dagermer goes in. Let me see, I have a letter in here. Okay, on January 9th, Mr. Coast met with Ms. Walden for a pretrial assessment. She's serving 93 days in jail on a district court contempt. She scored 9 on the assessment, which is the highest she can score. To be rearrested while out on bond and not likely to appear for courts. Oh, okay. All right, so Mr. Dagermer goes in. This is date and time set for pretrial. Did we arraign her last time? Or was it set over for rearrangement?
I think we arranged that. We set over for her to be screened for drug court, and that's happened at this point.
Okay, and do you know what the result was from her screening for recovery court?
Yeah, my understanding is she is eligible and will be accepted if she chooses to do so, and I've spoken with her, and that is the plan.
All right, Miss Teskey, is that correct?
That is correct, Your Honor.
All right, so your client's going to plead today?
Correct. In speaking and resolving this matter with the prosecutor's office, Ms. Walden will be pleading guilty to count 1 as charged under the condition that she, with no subs and habituals, under the condition that she enters and completes drug recovery court. And if she does complete it, this would be a deferred sentence. In other words, it would be dismissed at the end of successful completion.
Okay, so is that 7411 or?
It wouldn't be 7411. It would be the prosecutorial deferral discretion to dismiss the case at completion of probation.
All right, so, recovery court is one of those things where people violate, people struggle. I mean, it's not an easy process. So Mr. Sneed, so if she successfully completes it, this case would be dismissed?
Yes, the deferral is under the adult drug treatment court statute, Judge, so that is accurate.
I just don't think we've ever had one of these before, plea under that statute that I remember, maybe
No,
one.
but I love it.
Oh, I do. I want to make sure. Okay. All right. So, Miss Walden, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Okay. Can you state your full name for the record for me?
Kayla Ray Walden.
All right. So, Miss Walden, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count 1, controlled substance, possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison and or a $15,000 fine? Part of the agreement is that if you successfully complete recovery court, then this would be dismissed. So you would have no conviction on your record. Do you understand that?
Yes, Your Honor, I understand that. I do.
Okay, and you were screened for recovery court, and did you have an opportunity to talk with that individual about what is involved in recovery court?
Yes. Yep.
Okay, and it's your intention to enter into the recovery court program?
Yep, that is my intention. Correct.
Excellent, excellent. Are you satisfied with your attorney and the advice that he has given you?
Yes, I am.
Right, and neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Dagermer-Gosian?
Correct, Your Honor.
And is that correct as far as you're aware, Ms. Walden?
Yes.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Ms. Walden?
I do understand that, Your Honor.
Okay, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, I do not.
All right, so how do you wish to plead to the charge that on or about December 4 of 2024 in the village of Clinton in the county of Lenawee that you did commit the offense controlled substance possession of methamphetamine? Guilty or not guilty?
I'm going to plead guilty.
All right. Has anyone made any threats or promises to you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Dagger-Margosian?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Ms. Walden?
He's not giving me a promise of what my sentence may be.
So he hasn't said, you know, you'll do this much jail. He just said you'll probably be on probation. You have to comply with recovery court. Okay. Is it your own choice to plead guilty?
Yes, it's my own choice. Yes.
Okay. So Ms. Walden, on December 4 of 2024, were you in the village of Clinton in the county of Lenawee?
Yes.
All right. And did you have in your possession at that time methamphetamine?
Yes, I did, Your Honor.
All right. And did you know it was methamphetamine?
Yes, I did.
And did you have any legal right to possess that?
No, I did not.
Okay, very good. Are the people satisfied, Mr. Sneed?
I am, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, thank you.
Mr. Dagger-Margosian?
Yes, Your Honor.
All right, accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. I am going to refer this matter to the probation department for a pre-sentence investigation. Sentencing will be March 7. Are you available March 7, Mr. Dagger-Margosian?
Yes, Your Honor. Thank you.
Okay. So, Ms. Walden, I will set you for sentencing March 7 at 8:15 in the morning. Now, you can appear in person or via Zoom. How would you like to appear?
I would do in person, actually. Easy.
So we will set that in person. Now, Ms. Walden, Ms. Teskey is going to come over to the jail and she's going to interview you and do the pre-sentence report. It's really, really important going into recovery court that we have a full understanding of your illness and your addiction levels, okay? So be truthful with her about your background, the events that occurred, your addiction, and she will prepare a pre-sentence report. We'll get a copy of that to Mr. Dagger-Margosian. He'll review that with you before sentencing, and we will see you back on March 7 at 8:15 in the morning. So anything else, Mr. Dagger-Margosian?
Your Honor, the protocol for sentencing for drug court,
Yes, go ahead.
well, I was just going to say, if Ms. Walden, it has to be in custody until that point. I mean, I know the court has
She scored like the highest level on our assessment. So no, I'm not going to release her. Our protocol typically would be that she'll go from jail to inpatient treatment and a long-term program so that she can get a boost on her recovery. And that's really up to the recommendation of Ms. Teskey. And then obviously that could occur before sentencing or at sentencing, I'm not sure, but Ms. Teskey will reach out to us and provide that pre-sentence report. All right, Mr. Dagmar goes in.
Understood. Thank you, Honor.
All right, Ms. Walden, thank you so much. We'll see you back on March 7 at 8:15 in the morning, all right?
Thank you, Your Honor.
Thank you. And that'll be in person. Okay, so I have a young man joining me at the jail in room 3. What's your name, sir?
Mario Cooper.
All right, so let me grab your file. This is in the matter of the people of the state of Michigan versus Demario Alonzo Cooper, file number 25-22108AX. So Mr. Cooper, we are here on an extradition hearing. So extradition is a proceeding to determine whether you wish to waive your right to extradition. It is in effect a demand to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. Basically, the state is demanding that you be surrendered to them and returned to that state to face the crime with which you are charged. And this warrant comes out of the state of Ohio, Perkins Township, Erie County, Ohio. And they have, hold on, let me find this. Hold on. Every county does different stuff. What is this? McLean, Perkins County, Pennsylvania. Hey, Becky. You want to come in here?
Sure.
So I think it's charged in. I think it's this. It says. So I'm sorry. So although we're all, glad Ohio State won the game, I still struggle sometimes to read documents from Ohio. So basically what it says, Mr. Cooper, is that the complainant, Officer R. Smith of the Perkins Township. Sarah, you're not muted. Of the Perkins Township Police Department, 2610 Columbus Avenue, Sandusky, Ohio, in care of MD Philadelphia, Pennsylvania, states that on the 23rd of February, 2024, Demario Alonzo Cooper did with purpose to defraud or knowing that the person is facilitating a fraud, utter or possess with purpose to utter any writing that the person knows to have been forged during the course of an investigation at Mad River Harley Davidson 5316 Myland Road. Committed a fraud. And so evidently there was a fraudulent purchase and that you are being charged in Erie County, Ohio with a fraudulent purchase that is a felony in the state of Ohio. And so that is a felony in the state of Ohio. I mean, it would be in Michigan too. And we cannot, in this court, in this state, determine the truth or falsity of the charges made against you in the state of Ohio. You do not have to waive your right to extradition. You can require that the governor of the state of Ohio make demand upon the governor of Michigan for a warrant for extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, the court would appoint you one at county expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand the rights that I've just told you, Mr. Cooper?
Your Honor?
Are you on, Mr. Cooper?
Yes.
Well, I didn't know that.
I know. I didn't know there was going to be a hearing this morning.
This is an extradition.
All right, okay.
Are you on the extradition?
No, I would advise him that he needs to sign that so we can resolve that, but I haven't done, I didn't know about this extradition hearing.
Okay, so do you want me to set this over so you can Zoom with them? Or Mr. Cooper, do you understand you've got these charges in Ohio, right?
I would like to speak to legal representation first.
Yeah.
You would like an attorney?
Yeah, let me put that over for a week or so and I'll get over it. We've got a hearing coming up downstairs, I think tomorrow.
Okay, so Mr. Cooper, what I'm gonna do.
I have
it's
one
today,
today.
maybe.
Okay, I'll talk to you there then.
Do you want me to set this over to like tomorrow or Friday?
That's good.
Miss Adams, can I set this over tomorrow or Friday sometime?
I have another court date with Wayne County tomorrow, I believe.
Are you Zoom in for that one?
Yes,
What time is that one?
I'm not sure.
Okay, how about Friday? Mr. Daly, are you available Friday? Because I will accommodate your schedule.
There's also a requisite, Mr. McKenzie's already done.
Oh, really? Okay. Yeah, Casey brought them.
85.7.
Yeah, I'm available on Friday. Your Honor.
What would be a good time for you?
Give me a time, I can be there.
Miss Adams, what would be a good time, anytime Friday to bring Mr. Daly and Mr. Cooper back?
I would say probably 8 o'clock before your sentencings.
Would 8 o'clock be okay, Mr. Daly? Or,
Yeah, I've got a delayed sentence with you that morning anyway.
okay, all right. So is that via Zoom, your sentencing Friday?
No, I was planning on being here in person.
Okay.
It's a delayed sentencing for my,
All right, so Mr. Cooper, I'm gonna set this over to Friday morning at 8 o'clock. And then, do you want him brought over or Zoom?
I don't have him in person.
Okay, so Mr. Cooper, we'll have you brought over in person, okay, Friday morning?
Okay.
Okay, so Ms.
So will
Adams
we
will
talk
send
about the
this.
case today or how will that work?
No, I'm in the middle of my criminal docket, but Mr. Daly is gonna see you later today or something on another case and he'll talk to you then, all
I
right?
already talked to the prosecutor. I just got the case, I just talked to the prosecutor, and I'll talk to you today about what the possible resolutions can be and what we can do.
So
are
Mr.
we
Daly.
called today?
So we're done with, I only have you on the extradition, so we're done with my part. And I'm gonna adjourn the extradition over to Friday morning. Mr. Daly represents you on a different case in a different court. So he's gonna come talk to you or meet with you today and then he'll talk to you about my extradition too, okay?
Okay, thank you.
All right, thank you, Mr. Cooper, and we'll see you back Friday morning in person, okay?
Thank you.
All right, Mr. Daly, morning. So give me 1 second. Friday the 8th. And Miss Adams, no, that's Mr. Simpson. Okay, so Mr. Glazier, give me 1 second, Mr. Daly. Mr. Glazier, you represent Christopher Webb.
That's correct.
All right, do you have him at your office?
No, Your Honor, the last time I saw Mr. Webb was on September 11th, and he didn't, or I didn't see him that day, excuse me. He didn't show up, and you issued a
All right.
bench warrant.
Okay, in the matter of the people of the state of Michigan versus Christopher Aaron Webb, file number 23-21230FH. This is the date and time set for a pretrial conference in this matter.
Your Honor, was he picked up? I don't know why it would be set for today. You issued a bench warrant back on September 11th when he didn't show.
Well, he was arraigned, or there was a felony information in July. I don't know, Miss Adams, we did a notice of hearing for today back on January 6th. I have an order extending bond conditions dated September 30th. I have an amended felony information July 23rd of 24. I have he was arrested on a bench warrant back on May 28th of 24. And you must have sweet talked me into letting him out. So, Miss Adams, is there another, I don't have paperwork, but is there another active bench warrant in this file that's scanned into the ROA?
I'm checking right now. This looked like a notice was sent to him on January 6th, so somebody must have contacted us.
Is there an active warrant or no?
I'm looking, I don't see.
He might have a warrant on another file, but it looks like he showed up and I released him and now he didn't show up again. So I will issue a bench warrant for his arrest. And set bond in the amount of 25,000 cash. Oh, wait, Miss Adams. All right, so Mr. Glazier, a stipend order for a notice of hearing was never done for the September date. And so we noticed it for today. And he has not appeared today.
Okay.
And he has not appeared today, so I will issue a bench warrant for failure to appear, set bond in the amount of 25,000. Cash, if you are able to reach him or he contacts you, I don't sign those for 48 hours. And you can get him in, all right?
All right, thank you, Your Honor.
All right, thank you. So I do believe, where's done? I do believe that takes care of the 8:30 docket, the 8 a.m. docket, and the 8:15 docket. So now, Mr. Daly's here with Casey McKenzie, Miss Underwood, Jonathan Rodriguez, or Gonzalez Rodriguez is not in custody.
He's on MDOC, Your Honor. I don't know if he's in the building yet.
No, he was supposed to be Zoom.
He was supposed to be Zoom. So in the matter of the people of the state of Michigan versus Jonathan Gonzalez Rodriguez, file number 23-21565FH. He is neither in the building and he is not on Zoom. So we will reschedule this for March 5. Did he request to be in person last time?
Your Honor, this was a hearing that was scheduled by Ms. McClure at her behest because she wanted to get a new trial date, Your Honor. She is unavailable that day. And I was going to talk to Mr. Gonzalez Rodriguez. I thought he would be here in person.
So, I don't have a notice of hearing for today in my file, and I don't show a writ, so he's set for trial. Yes, Ms. Adams.
I'm sorry, I have email correspondence with MDOC and the prosecutor's office requesting Zoom today.
Okay, well, he's not here, so I can set this over to next Wednesday, Ms. Underwood, to try to get him here.
That would be, from what I see in my file, he's at Gus, Your Honor. So maybe I can't promise anything.
Okay,
I could
so we'll
actually-
set this, we'll set this over to January 29 at 8:30 in the morning, in person or Zoom, Ms. Underwood?
I would prefer in person, Your Honor.
Okay, and Mr. Sneed, can you make an, I don't know who emails to get MDOC here, but Ms. Adams or Mr. Sneed?
I will, Judge.
All right, thank you. All right, so that takes care of Mr. Gonzalez Rodriguez. Ms. Underwood, I'm waiting for
Mr.
my
Paul?
pickup, but he's not here yet. So I'm sure we've called for him. All right, so Mr. Daly. So in the matter of, you can go up there with Mr. Daly. In the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 24-21789F8. I have Dave McCready appearing on behalf of the people and Mr. Daly appearing on behalf of Mr. McKenzie. So I have a lot of Post-its on this file. So where are we today, Mr. Daly?
Your Honor, today I've had an opportunity to discuss this with Mr. McKenzie. There'd been a plea bargain made by the prosecution, which is unacceptable to Mr. McKenzie. He wants to set this matter for trial. He wants to go to trial, and he's concerned that his case keeps getting adjourned without his consent. I've told him that I will not agree to adjournments without his consent, and that's very important to him.
Okay.
But right now, we're just looking for a trial date, and we are proceeding to go prepare for trial.
Okay, so Miss Adams, could I get the red book, please? How many days do the people need for this?
2 days is fine.
2 days, 2 days, Mr. Daly?
That's fine.
All right, so Miss Adams, I know I have a trial date opened up pretty soon. So next week's probably too soon. So I had a trial just fall out today. So, okay, so I can do February 5 too soon.
I could try to get my people together by then.
By when?
February 5. I just
2 weeks.
2 weeks. Is that too soon? It's fine. Oh, I have Tuesday, February 11. That's 3 weeks. That should be good enough to get witnesses in, maybe.
You want to talk to me, Casey? Well, I can get ready for that. I can't do it that day, Your Honor.
Okay, so I can do. All right, so the first week of March, I have an individual set for trial who's in jail. And a murder trial. So, I can do March 18. I bumped my civil trial, which is great. So.
That'll be on the 18th.
Yes, sir. 18th, 19th, it could go into the 20th if needed.
That'd be fine.
Fine with people.
Okay, so we will set trial for March 18. Tuesdays are at 9 a.m. Wednesdays start at 10:30 after our criminal docket. I'm going to require that jury and Miss Adams, I'll need a copy from Mr. McKenzie of this when I'm done. I'm going to require that jury instructions and voir dire questions be provided by February 28th. I'm going to make that a motion deadline as well. So that'll take care of all of that. And Mr. McCready, I usually take pleas up until the time the trial starts.
That's fine.
Okay, so understand the plea offer would be available until 9:05 or when the trial starts. All right, Mr. Daly?
That's fine, Judge.
All right, so I'm going to sign this. Jason, 22nd. And Ms. Adams, could I get a copy for the attorneys and Mr. McKenzie? Thank you. All right, so just bear with us for a moment. We'll get you copies. Okay. All right, and I am going to go off of live stream at this point.
I'll try to do that.